You've brought a lawsuit against your doctor claiming that because of his carelessness, you now suffered significant harm and injury. And now, before your case ever gets to trial, the defense lawyer makes a request to the judge to throw out your case before ever getting to trial. It's called a motion for summary judgment, and you are furious. Can you go onto Facebook or on social media and now rant all about how the defense is being unfair and not giving you the chance to get to trial? You want to know the answer? Come join me for a moment as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is no, you cannot go on social media. You cannot go on Facebook and start ranting about what the defense is doing. The defense has every legal right to try and get your case dismissed before you get to trial. This is a formal request to the judge known as a motion. A motion seeks to compel the judge to do something. A motion for summary judgment seeks to get your case dismissed before you ever even get to trial for a jury to consider your case. And now they have to have certain legal reasons for doing that. But can you go on social media? No, you can't. Your attorney should have told you at the very beginning of the case. You are not to go onto social media at all to discuss this case, to discuss your activities, to discuss your injuries. Why? Because all of that information can be used against you in your lawsuit. The defense scours your social media profiles to see if you're posting anything that contradicts anything you're claiming in your lawsuit. And now, if you were to go onto social media and start ranting and raving about the justice system and what the defense is doing and how terrible they are, guess what? All of that is going to come back to bite you in the butt when your case, if your case gets to trial. Why? Because now they're going to pull out every single comment that you made to show that you are biased. Every single comment to show that you have an agenda. And why is that going to hurt you? Because now it looks like you have an ulterior motive for bringing this lawsuit. Now the defense will do everything possible to shift the focus of the case from the facts, from the issues in the case about whether the doctor did in fact violate the basic standards of medical care, to instead focusing on you and your agenda. It's just like what's going on in the debates where each side, Trump is pointing fingers at Clinton, Clinton's pointing fingers at Trump, and guess what? They're both claiming that the other is unfit to be president. But what they're not doing is that they're not telling everybody why they should be president and what they can do to help the country. So you don't want the defense attorney, you don't want to give them an opportunity to start changing the focus of the trial from the facts of the case to things that have nothing whatsoever to do with the trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these malpractice cases here in the state of New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.